kick off our lawyers community and impact with a tradition actually that goes back of our Supreme Court Roundup. It's a long tradition at Columbia, and we merged that old tradition with a new tradition when we began the Lawyers Community and Impact program. So just to give a little bit of background on what we affectionately refer to as LCI at this point. So shortly after I became dean, I was in conversation with a number of members of the student body, as well as members of the faculty and the administration, about how we could, there are lots of different events and programs that focus on people with a particular set of interests. You know, you were in a class with people with a particular set of interests with you, or you were in a student org that meets about a particular set of issues. And we wanted to, there was a hunger for a forum in which people could all come together and across all different kinds of interests and career paths and the years of law school, and talk about issues that take the things that we're learning in the classroom and connect them with events in the world around us. Connect them with things that we're reading about in the newspaper, or that, you know, that we know are happening in say politics or in law reform or just civil society issues that are urgent issues of whatever time we're in during that arc of our academic year. And it's been a wonderful thing. We have several a semester, and it involves bringing thoughtful people together, members of our faculty, guests from outside our faculty, to share their insights and to stimulate conversations across the student body that allows us to see the meaning and the impact of the law and the ways that we can apply what we're learning to be people who are engaged citizens, who see how we can use the tools we're picking up to make a difference, to change, to interrogate, to challenge the events around us. So Dave Pozen is the Vice Dean for Intellectual Life, who just joined a 2-year term. And this historically also is co-sponsored between the Vice Dean for Intellectual Life and the Dean of Students, Dean Yadira. And so, and then depending on the event, there might be other co-sponsors who join. So, so you'll always be introduced by a group of people who've all come together around this. So I'm not going to say more, except to say that I'm delighted to see our wonderful group of panelists. I will not be making those introductions. I'm really just introducing the series, saying hello, welcoming you all, and looking forward to some very stimulating conversations in the year ahead. Thanks so much.
Great. Well, thank you, Dean Lester, for kicking us off. And I also want to thank the Office of Student Services and Social Justice Initiatives for making this event happen, and also the American Constitution Society and Federal Society chapters of the law school for co-sponsoring. As Dean Lester said, this is part of the LCI series and the traditional opener for the series. The next event in that series will be October 19th. You'll get more information about this in the coming weeks, on criminal injustice and reimagining the criminal justice, racial injustice and reimagining the criminal justice system. This event is the Supreme Court Roundup, and we have an extraordinarily distinguished group of panelists. I will introduce them very briefly in the interest of time, and then say a word about the format. So in the order in which they'll be speaking, we have Elora Mukherjee, who is the Jerome L. Green Clinical Professor of Law here at Columbia Law School and the director of our Immigrant Rights Clinic. Next, we'll have Nancy Northup, who is the president and CEO of the Center for Reproductive Rights and a distinguished graduate of this law school. Then we have Tom Schmidt, who is a new academic fellow at the law school, who previously was doing high-level appellate litigation and briefed numerous cases at the Supreme Court. And last but not least, we have Suzanne Goldberg, who is the Herbert Endorsed Wexler Clinical Professor of Law at the law school, and also the university's Executive Vice President for University Life. So each panelist in that order will get up to 8 minutes to speak about a specific important case from this past term. And then I'll kick things off by offering a few broad questions to the panel, and then we'll open it up to the full group for Q&A, either by sending chat questions to student services or by raising your hand in the Zoom function and calling on you that way. Okay, so to get right into it, we have Professor Mukherjee talking about the DHS versus Regents case.
Thank you so much, Professor Pozen, and thank you everyone for coming this afternoon. It's a pleasure to have so many students and other participants in our community coming out. So let's start at the beginning. The Daca case, the foundation for the Daca case was laid during the Obama years. In 2012, the Department of Homeland Security issued a memorandum announcing that those who were undocumented and brought to the United States as children could apply for 2-year temporary reprieves from deportation. In addition, those who qualified for the DACA program, which stands for Deferred Action for Childhood Arrivals, could critically apply for employment authorization, which would enable them to work legally in the United States, and they were entitled to several other federal benefits. Over time, between 2012 and about 2017, more than 70,000 people came out of the shadows and became DACA holders, became officially recognized by the federal government as dreamers. Then we had a change in administration, and in September of 2017, then Attorney General Jeff Sessions asked Acting Secretary of Homeland Security Elaine Dukes to rescind DACA. He said that DACA was unconstitutional and an illegal program, and the following day, Acting Secretary Dukes, issued a memorandum saying that DACA was illegal, that it had legal flaws. She explained that the Department of Homeland Security would no longer accept new DACA applications. She also said that those who had DACA could apply for a DACA renewal if their DACA periods were set to expire in the coming 6 months. But for anyone else, they were out of luck. Their DACA would expire and they would be subject to deportation. Almost immediately, several plaintiffs and plaintiff organizations, so immigrants' rights organizations across the country, filed suit to challenge the September 27 rescission of DACA. Those cases were built on 2 primary legal grounds. First, a theory under the Administrative Procedures Act, arguing that the rescission of DACA was arbitrary and capricious. And second, an argument built on the Due Process Clause of the Fifth Amendment, arguing that the rescission of DACA deprived dreamers, DACA holders, of equal protection of the law, given the Trump administration's, and especially the president and his closest advisors, many vitriolic, racist, xenophobic, nationalistic comments about immigrants, especially those from Mexico and Central America. So what happened in the Supreme Court? So in a decision that surprised many people across the country, including many immigrants' rights advocates, the Supreme Court held that the rescission of DACA was arbitrary and capricious under the Administrative Procedures Act. It was a 5-4 decision, and the court did not uphold the plaintiff's arguments with respect to the Equal Protection Clause. Now, in dissent, Justice Thomas wrote, quote, "This is anything but a standard administrative law case." And I want to pull up a few slides that hopefully will help to illustrate this point. So when Justice Thomas wrote that this is anything but a standard administrative law case, I want to agree with him. And I think we need to look outside the contours of the DACA decision to understand it. So the DACA decision, DHS versus Regents, is the product of an extraordinary social movement that has been built by Dreamers over the last 20 years. As many of you may already know, the Dreamers have been executing a brilliant legal strategy, organizing strategy, public relations strategy for more than 20 years now, which resulted first in the DREAM Act being introduced in Congress in 2001, Then over the next 5 to 7 years, the undocumented immigrants who became the Dreamers started focusing on a congressional strategy trying to pass the DREAM Act. Now that failed spectacularly in Congress in 2010, and then the Dreamers moved on to an executive branch strategy focused on the Obama administration. As some of you may recall, the Dreamers engaged in sit-ins, in hunger strikes, and other forms of civil disobedience, and they made their presence in the United States widely known. And they were incredibly successful in this movement. So public opinion polls of Americans in general show that the overwhelming majority of Americans believe that the Dreamers should be allowed to stay. And the same polling is reflective in our public officials. A majority of lawmakers across both aisles support the Dreamers. And there's no other group in American history in recent times that has achieved this kind of temporary reprieve from deportation. And this photo that I'm showing in the slide here illustrates some of the striking imagery that Dreamers use when they're publicly organizing. They often rely on striking images of butterflies to showcase their migration to the United States. A large part of their narrative is that we are American, we are here to stay, and that history will judge you cruelly if you oppose us. And Chief Justice Roberts, in my view, didn't want to be on the wrong side of that history. Now, what happens after the Supreme Court's decision? So the Supreme Court's decision says that the rescission of Daca was arbitrary and capricious. What this means is that Daca should be reverted to the program it was in 2012. This means specifically 3 things. The administration should accept new Daca applications. The administration should accept Daca renewal applications, and the administration should process advanced parole applications, which would allow Dreamers to travel abroad, which they haven't been able to do since the Trump administration came to office. Now, this seems pretty easy to implement, but the administration has not followed the Supreme Court's ruling. About 6 weeks after the Supreme Court issued its decision in DHS versus Regents, Acting DHS Secretary Chad Wolf issued a memorandum on July 28th saying 3 things. First, the Department of Homeland Security would reject Daca applications. Second, the administration would only consider advanced parole requests in exceptional circumstances, and these have my understanding is these have not been granted since that July 28th memo. And third, instead of allowing renewal periods of 2 years, which gives Dreamers some sense of security, the renewal periods, the temporary reprieves from deportations, would only be 1 year. Now, these material changes to the Daca program are at odds with the Supreme Court's decision and are at odds with the Federal District Court from Maryland decision that came down after the Supreme Court's rulings. Now, if Daca were reverted to the program it was in 2012, this slide shows the data of who would be immediately eligible to apply, who would be eligible to apply if they meet the educational requirements, and it also tallies the 30,000 children who would be eligible for the program once they turn 15, provided that they remain in school. Now, in my last minute or so, I just want to highlight the real human consequences for those who are in limbo right now. So on the left of the slide, you'll see Jack, and on the right, you'll see Owen. So Jack is 20 years old. He is on track to become a mechanical engineer, and he, unlike his brother, Owen, is planning to go to college. Owen has resigned himself to become a mechanic. Both brothers were born in Mexico, brought to the United States as children, and their status as dreamers of Mexican origin is reflective of Daca numbers. More than 80% of dreamers were born in Mexico. More than 94% are from Latin America. And their paths have diverged over time because Jack is a beneficiary of Daca. That enabled him to obtain a work permit, obtain a social security number, a driver's license. He's able to apply for financial aid, which enabled him to attend college. And he now has a job that pays $13 an hour, and he works 6-hour shifts and is saving up in his 401k. In contrast, just days before Owen turned 15, the Daca program was rescinded. As a result, Owen shifted out of a college prep track in high school, and it was because he knew he couldn't afford college or use his degree. He decided to train as a mechanic. He works 12-hour shifts from 2 p.m. to 2 a.m., earning about $6 an hour. He gets no workers' compensation or sick leave. And I think this illustration of these brothers helps us to understand the transformative effect that the Daca program can have on the lives of its recipients. And if the Trump administration continues with Daca in its devastated form, we will continue to see in our country what may become a permanent subcaste of people who are not able to advance in education and employment and other spheres of life. Thank you.
Thanks so much, Professor Mukherjee. We next have Nancy Northup to talk about the June Medical Services versus Russo case.
Great, thank you. And it is good as always to be back at Columbia Law School. So I too am going to back up just a little bit before talking about the case from last term, June Medical Services versus Russo. Just to set the context for this, this is an abortion rights case, it's an abortion access case, and you really have to start in 1992 with the Planned Parenthood versus Casey case. That was a decision where everybody was concerned that the Supreme Court was going to overturn Roe versus Wade. There were new appointees on the court. It was unclear how they were going to vote. But in 1992, in a plurality decision with Justice Kennedy, Souter, and O'Connor, came up with a standard for abortion rights cases that if there was an undue burden on a particular law that a state or the federal government had passed that had the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion, then it was unconstitutional. That's what they said about it. They ended up striking down a requirement from a Pennsylvania law that a woman would have to let her husband know that she was getting an abortion, so that was found to be a unconstitutional undue burden. But they upheld a law that required a waiting period and some counseling for a woman before she had an abortion. So then what came after that was more than 2.5 decades of a lot of litigation around what is an undue burden, what does the standard mean, and really the Supreme Court took very few cases between then and the case I'm going to talk about in a minute, Whole Woman's Health versus Hellerstedt in 2016. So meanwhile, there was an avalanche of laws that kept coming at the state level, testing what that undue burden standard was. And that really picked up after 2010. There was a sweeping political change in the Congress in that year and also in the state houses with the Tea Party. And so we began to see many more burdens. So since that 2010 election, about 450 restrictions on access to abortion have been passed at the state level. And there are all kinds of restrictions. There are bans on abortion before viability, which has been the standard since Roe versus Wade, that the government cannot ultimately ban abortion before fetal viability. Yet we're seeing time limit bans, 6 weeks, 15 weeks, 20 weeks, bans for reasons, the sex of the child, the fetal diagnosis, bans on who could provide abortion services. If it was a Planned Parenthood that gets family planning funding, some states banned them from being able to provide abortion services, bans on how to pay for abortion services, that private insurance companies couldn't cover services without a special rider, plus sort of what we think of as patient manipulation laws, forced sonograms are unnecessary for the procedures, waiting periods, longer and longer waiting periods, misinformation about the links between abortion and, say, breast cancer or mental illness. But the most effective of these in actually making it really hard to access abortion services are what are known as trap laws, or targeted regulations of abortion providers. And these are laws that are passed that don't have anything to do with medical safety, but everything to do with shutting down clinics. And two in particular became the core of this case in 2016, Whole Women's Health versus Hellerstedt. One was a requirement, this came out of the state of Texas, that all abortion services be done at ambulatory surgical centers. Those are like mini hospitals. Abortion procedures are by and large done the first trimester, and they're by and large outpatient procedures, so not necessary to be done in a hospital level setting, which increases expense considerably than a doctor's office. And second, that doctors have admitting privileges in a local hospital. And what was established in the Texas case and many other cases were that because abortion is a very safe procedure, rarely are patients needed to be admitted at a hospital, and therefore providers don't have admitting privileges because hospitals give them to doctors who admit patients and treat them in the hospital, or for other reasons of just bias against providers. So this was the case coming out of Texas, 2016. It was another moment where because the impact of this law, it had already closed, the admitting privileges provision had closed half the abortion clinics in the state of Texas, and the ambulatory surgical center law was going to close another 50% beyond that. So the Supreme Court, in a 5-3 decision, there was one vacant seat on the court because Justice Scalia had died earlier that year, but in a 5-3 decision written by Justice Breyer, joined by Kennedy, Ginsburg, Sotomayor, and Kagan, they ruled that this Texas law, and I'm just going to focus on the admitting privileges because that's what came up again this year, was an undue burden. And that was because it had no medical benefit, and it had the substantial burden of closing half the clinics in Texas for no reason. And Justice Ginsburg wrote a separate opinion really to underscore, as she said later to a press interview, that these states need to cut it out and stop passing laws that were really pretextual and trying to do by the back door what they couldn't do by the front, which was just outright ban abortion. And you flash forward and we get to the June Medical Services versus Russo case that the Supreme Court heard this year. And you might think, what was this case doing in the Supreme Court? It was the same issue, Louisiana, copying the Texas law way back before that case was decided in the Supreme Court, had decided to pass an identical law because, as one of the lawmakers said at the time, it was proving so effective in shutting clinics in Texas. So they wanted to do it as well. And the district court found that law also to be a burden with no benefit. Supreme Court case comes down in Whole Women's Health. And unlike the other states, many who just dropped trying to pursue their admitting privileges law, Louisiana persisted, basically in open defiance of the Supreme Court's ruling in Whole Women's Health. And the district court found that no, based on the facts, it had no benefit and had a huge burden. Goes up to the U.S. Court of Appeals for the Fifth Circuit, which retried the facts themselves, which all of you know is not something that appellate courts do, and also went back to the standard that had been reversed in the Whole Women's Health case. So they kind of openly defied the Supreme Court's ruling. And you might think, well, why in the world would the Fifth Circuit be doing that? What had changed since the Whole Women's Health case? Well, first of all, that one seat had been filled. Justice Scalia's seat had been filled by Justice Gorsuch, and Justice Kennedy had retired. The fifth vote for the Whole Women's Health case and had been replaced by Justice Kavanaugh. So 2 new justices on the Supreme Court, a different lineup. Again, Chief Justice Roberts had been in dissent, and it was unclear what was going to happen. So the Fifth Circuit had ruled against our clients, which is an abortion clinic in Shreveport, Louisiana, that serves, there's only 3 clinics in the state of Louisiana, and they serve also women coming from Texas and from Oklahoma and even as far as Arkansas. So this goes up to the Supreme Court, same issue, and it was interesting to be litigating the exact same issue. It was the same law, and it had as devastating an effect. In fact, it would have left just one doctor in the state of Louisiana to serve the over 1 million women of reproductive age. So it was tough. All eyes were on Chief Justice Roberts because he'd been in dissent. But when we got the decision in June, Chief Justice Roberts voted with the 4 other justices still on the court from the whole women's health majority that the law was unconstitutional. So that was a tremendous win, but it was also unbelievable how much work had to go into getting the same decision on a case that was on all fours with one from 2016. Now, in that case, Breyer wrote the plurality opinion, and he went back to stating the standard in whole women's health, which basically was a balancing test about this undue burden, that you look both at whether there is any benefit to the law, and then you look at whether there's a burden, and found that Louisiana had demonstrated, as had been the case in Texas, that abortion is very safe, that patients don't get admitted to hospitals, and that admitting privileges would do nothing to advance health and safety. They weren't a credentialing requirement. Hospitals give them out so that they have doctors who practice in the hospitals. It also found that there were burdens that were substantial, which I've mentioned. The doctors were unlikely to get the privileges for the same reasons as in the state of Texas. And that also it would increase, therefore, if the clinics, we went down to 1 doctor in the state of Louisiana, longer wait times, longer drive times, and patients would be faced with overcrowding, unable to get perhaps the procedure they wanted, the type of appointment when they needed it, and that the burdens would really fall on the low-income women that are served by not just our client in Shreveport, but really by the 3 clinics in the state of Louisiana. And also that the Fifth Circuit was wrong to have overturned the trial court's fact findings, and that there was substantial evidence to support them. Now, Chief Justice Roberts did not join that opinion. Chief Justice Roberts wrote a concurring opinion, striking down the law on stare decisis, basically saying because Whole Women's Health had rejected an identical statute, even though he does not agree with that decision, he thinks to this day it's wrongly decided, but they had determined that this burden in Texas was unconstitutional. Louisiana similarly had such a burden. Now, he wrote concurrence, however, to say that he would adopt a different test, not a balancing test about benefits and burdens, that he would look to the burdens, but that he would only think about benefits as sort of a threshold question about whether they're reasonably related to a legitimate government interest. Now, all 5 of those justices also rejected there was a third-party standing claim that the abortion providers could not actually raise the constitutional claims of their patients. And all of the 5 justices, including Chief Justice Roberts, said that has no merit. Now, there were 4 dissents, and they each wrote their own opinions. And so they're off to the races. So what's next after this case? I mean, even before the death of Justice Ginsburg last week, there were a lot of stuff going on in the lower courts about what does this opinion mean, and arguments being made by states with restricted abortion laws that Chief Justice Roberts' opinion is now the controlling legal standard. We have come back strongly, and most lower courts have agreed that you cannot change the standard by being a concurring justice in a opinion, that his single vote doesn't create a common denominator on how to apply an undue burden standard. Instead, I mean, he is disagreeing with the other 4 justices who explicitly affirm the balancing test, but he can't change the legal standard by writing a concurrence with the majority. So most lower courts have agreed with that. There'll be more battles to come. And obviously, with now the vacancy on the Supreme Court, this was a 5-4 decision, and one of those 5 votes is no longer on the court. And so we're expecting not just what will happen when the next abortion rights case gets to the Supreme Court, but what we have seen again and again and again is that both those who want to pass restrictions will be moving to do even more extreme restrictions in the hope they will ultimately get upheld, but also that some lower courts will be quite activist, as the Fifth Circuit was in the geomedical case, in going beyond the Supreme Court's precedent and running with some kind of rogue opinions. So that is what is up next, and we, as those who are pursuing access to abortion services as a right under the US Constitution, are quite concerned.
Thanks so much, Nancy. Next, we have Tom Schmidt on Trump versus Vance and Trump versus Mazars.
Thank you, Dave. And it's really great to be here to discuss a very interesting term with you all. Cyrus Vance is the district attorney of New York, and as part of a grand jury investigation, he subpoenaed Trump's personal accounting firm, requesting a bunch of financial records relating to the president and to the Trump organization, including explicitly the president's tax returns. In response to that, President Trump sued in federal court to try and enjoin enforcement of the subpoena. And his core argument was that he was absolutely immune from state criminal process. Both the district court and the Second Circuit rejected that argument, holding that the president's not absolutely immune and is not subject to a higher bar to the extent he is subpoenaed in the course of a criminal proceeding. And the Supreme Court affirmed. The majority opinion was written by Chief Justice Roberts and joined by 4 others. And it began with a tour of history. He started with the Burr trial from the early 19th century, which was presided over by Chief Justice Marshall, sitting in his capacity as a circuit justice. And in that case, Marshall subpoenaed President Jefferson for documents relating to the prosecution of Aaron Burr for treason before the trial. And in the centuries since, as the chief's opinion documents, a number of presidents have complied with subpoenas in criminal proceedings, at least voluntarily, and with a fair amount of flexibility and sort of, logistical changes and timing changes built in. The most famous of these instances was probably United States versus Nixon, where the court required the president to turn over tape recordings of Oval Office meetings, which ultimately led to President Nixon's resignation. These were all federal criminal proceedings, though. So the question before the court was whether state criminal proceedings are any different. And the Chief Justice found as a general matter that distinction shouldn't matter. That state criminal proceedings would not divert the president from his official duties any more than a typical civil suit, which the Supreme Court had upheld as okay in the Clinton versus Jones case in the 1990s. And the chief found essentially that the law already had some mechanisms in place to prevent the president from abusive or overbroad injunctions. The court then rejected a higher standard that might be applicable to subpoenas directed to the president's information. The Solicitor General, which participated in the case as an amicus because President Trump was litigating in his individual capacity, had endorsed this heightened standard, and it was borrowed from the United States versus Nixon case. And the court essentially said that Nixon was about material subject to executive privilege, and since this was the president's personal documents, it didn't really make sense to transplant that standard root and branch into this new context. At the same time, the court was pretty careful to point out that even if the standard is formally the same, courts should be sensitive to the fact that they are dealing with the president, not a normal individual. And for that kind of sensitivity point, they relied on Justice Breyer's separate opinion in the Clinton versus Jones case. The court did lay down a couple red lines that said you can't use a criminal subpoena as a political attempt to influence the president and the performances of his official functions. And the chief said it may be possible to show on a case-by-case basis that a particular subpoena is too burdensome, but by and large, it was a win for the district attorney, Cyrus Vance. The court was unanimous on the absolute immunity point, as the chief pointed out. Justice Kavanaugh and Justice Gorsuch concurred in the judgment, but they would have adopted the heightened standard from Nixon that the Solicitor General had endorsed before the court. And then Justices Thomas and Alito both dissented, apparently advocating for an even more stringent standard and formally vacatur of the opinion below rather than affirmance. So that's the Vance case. The Mazars case, Trump versus Mazars, dealt with 4 subpoenas, similar in scope to the subpoena in the Vance case, that had been issued by 3 different committees of the House of Representatives. I won't go into the details of all the subpoenas in the interest of time, but I will say that I think the way this case will ultimately be resolved in the district court could very well depend on the kind of details of both the breadth of the subpoenas and the legislative purpose behind them. But anyway, the subpoenas were upheld by the lower courts. It was different cases that got consolidated in the Supreme Court, in the Second Circuit and the DC Circuit. And this time the Supreme Court vacated and remanded. The Chief Justice wrote for 7 justices. And he began by noting that historically speaking, these sorts of disputes have just been worked out politically through negotiations and accommodations. And it's quite extraordinary for a case like this to land in the Supreme Court's lap. And he said that that history of accommodation would at least inform the way the court would resolve the case, although it's a little unclear exactly what he meant by that. And then the first part of his opinion upheld the general congressional power to obtain information from private parties by subpoena, as long as it's related to or in furtherance of a legitimate task of Congress. The court then again rejected the idea that there ought to be some special heightened standard from the Nixon case, which again was in the executive privilege context, applicable to the subpoenas here. At the same time, the court rejected the House's position. In other words, it said that the court and courts generally evaluating these subpoenas couldn't ignore the fact that these papers and the information at issue belong to the president. And in the court's view, the House's position would have left essentially no limit on the House's capacity to subpoena the private documents and information of the president, which would leave open the possibility of either too much leverage or harassment, political harassment. So the court then articulated a kind of middle ground 4-factor test for how courts should evaluate these sorts of disputes going forward. The court said, first, you have to assess whether the particular legislative purpose asserted warrants the pretty significant step of involving the president at all. You can't just rely on the president to get information to the extent that same information or comparable information is available elsewhere, and you can't just use the president as a case study for general legislation. Second, he said, the chief said, courts should insist on subpoenas that are no broader than necessary to achieve the legislative purpose that's been asserted. Third, he said courts have to be attentive, was the word he used, to the particular evidence that's offered by Congress to substantiate the legislative purpose that it's pursuing. And lastly, courts should evaluate the burden imposed on the president and the functioning of the executive branch imposed by the particular subpoena. Justice Thomas again dissented on the pretty broad ground that Congress has no power at all to subpoena information from private parties, president or non-president. And Justice Alito also dissented, explaining that in his view, congressional subpoenas of this kind directed towards the president are inherently suspicious, and outlining what he thought the House would have to show on remand in order to prevail in a case. So a couple thoughts about the implications of these decisions going forward. The first and I guess most practical question is whether the tax returns at issue in these cases are going to come to light in some way before the election. And I think it seems exceedingly unlikely that either of these cases is going to result in the release of the president's tax returns in the near future. In the Vance case, Judge Marrero, who's the district court judge in the Southern District of New York, who's been handling this case, upheld the subpoena once again on remand and dismissed the president's suit, finding the subpoena was not overbroad or issued in bad faith. That case is now in the Second Circuit. The president appealed immediately, and the Second Circuit is actually holding oral argument tomorrow. The one notable thing to come out of the briefing, which I have not read closely, but based on news reports, is that the district attorney's office suggested that it was investigating the president personally for tax fraud. That was a couple days ago in the New York Times. But I think the bottom line is, even if the Second Circuit were to affirm in short order in the next couple weeks, the evidence that was turned over pursuant to the subpoena would probably be protected by grand jury secrecy laws. In the House cases, the DC Circuit ordered supplemental briefing after the Supreme Court's opinion, and it's scheduled oral argument for October 20th. So that's not going to be until pretty close on the election. Interestingly, the new chairwoman of the House Oversight Committee issued a memo in light of the Supreme Court's decision, elaborating on the committee's rationale with some sensitivity to the 4 factors that the court had articulated. And as for the other subpoenas, which are in the Second Circuit, the relevant committees there have narrowed the subpoenas and filed a letter brief with the Second Circuit asking them to uphold the subpoenas just on the record before them. President Trump has asked the Second Circuit to send it all back down to the district court on remand. And those filings have been pending for about a month. And as far as I can tell, the Second Circuit has not done anything yet with them. In terms of other implications, I do think the Vance case is obviously significant in affirming that the president is subject to criminal process and specifically is subject to the same formal standard as anybody else when it comes to criminal process. I think it's important, though, not to lose sight of the substantial procedural protection that's afforded to the president by this opinion. And what I mean by that is generally speaking, and hope you'll forgive the law shop talk for a second, but generally speaking, a doctrine known as younger abstention would prevent federal courts from getting involved in ongoing criminal proceedings at all. And here, the Second Circuit held that younger abstention wouldn't apply, and the Supreme Court didn't even take the issue up. So I think the pretty clear indication of the opinion is that the president is going to get a federal court pretty closely scrutinizing any subpoena that's issued to him or her, and that's a pretty significant procedural protection that's not available to a typical citizen. And in the Mazars case, again, the court articulated this 4-factor standard, which seems to be only applicable to the president's information. So you get the sense that the court didn't relish the role of being the referee of these disputes. It would be willing to and step in and protect the president if necessary. And of course, the factors that it articulated in the opinion are going to inform the political process of negotiation and accommodation going forward. And then finally, and most broadly, I think you could take the reiteration of the basic structural principle in these cases that the president is not above the law and subject to the law, as well as I think the strongly functionalist orientation of these opinions as evidence of the judiciary and the Supreme Court's increasing willingness to ensure that the executive branch and the president in particular abides by the law and will be subject to review to the extent he or she acts ultra vires. But I think we'll have to see how that plays out. And I think that could very well be affected by, of course, the filling of the vacancy and the election that's coming up in November.
Thanks very much, Tom. Finally, for the opening remarks, we have Professor Goldberg talking about what is arguably the biggest blockbuster of the whole term, Bostock versus Clayton County.
Great. Thanks, Dave. And it's just great to be with everybody, with all of the speakers and with all of the students and other colleagues here. So thanks again to everybody who had a hand in organizing this. It is hard to talk about Bostock versus Clayton County without thinking about Justice Ginsburg, on whose work, on whose entire legacy really a decision like this sits, and whose vision of equality and of a world in which the government may not draw sex-based lines without an exceedingly persuasive justification closely, substantially related to its goals. That was, got myself twisted up there. It's hard, everything in Bostock is on a Justice Ginsburg landscape, or on a landscape that she shaped in a fundamental way, the very idea that sex discrimination is impermissible and what that means. So the decision itself, Bostock versus Clayton County, actually involves 3 cases, 3 people: Gerald Bostock, who was a county employee working in child protective services and was a stellar employee, and then was fired for conduct unbecoming a county employee after some of his colleagues discovered that he had joined a gay softball league. There was Don Zarda, who was a skydiving instructor fired by his employer after he told a client that he was gay. And Amy Stevens, who told her employer, the RG and GR Harris funeral homes, that she intended to come back to work after a break as a woman. She had previously been working identified as a man, and she was fired as well. So 3 people fired because of their sexual orientation or gender identity. So the issue in the case is actually quite straightforward, which is we have a federal law, Title VII, that prohibits employers from discriminating against employees and also applicants because of race, color, religion, sex, and national origin. And so the question in the case is, does Title VII's prohibition against sex discrimination provide protection if somebody is fired for being gay or lesbian or transgender? The short answer is yes. We have a 6-person majority opinion. The opinion is by Justice Gorsuch. There are 2 dissents. The first is by Justice Alito, joined by Justice Thomas, and the second dissent is by Justice Kavanaugh. So I want to talk a little bit about the opinion, why it matters, and what's next. There's so much in the opinion, as there is in all of the opinions my colleagues just talked about, and I really want to encourage you to take a look at this one. It's not a heavy, hard lift to read. It's very interesting and really worth digging into. But like I said, fundamentally, the case is about the meaning of the word sex in Title VII, which is a statute, again, a federal law enacted by Congress in 1964, amended in 1991. It is not a constitutional case. It's a statutory interpretation case. So in this case, the employers defended themselves in several ways, and I'll focus on 2 that were really embraced by the dissenters. First is about the definition of sex, and the argument is basically, when Congress enacted Title VII, the members of Congress, like everybody else, they say, understood that sex meant men and women. It didn't mean gay, it didn't mean transgender. And they argue the same is true today. And the court is overstepping to decide that sex discrimination provides protection for gay, lesbian, bisexual, and transgender people. Right? It's overstepping because it is applying Title VII in a way that Congress did not intend. The second main defense is that the employers were actually treating employees equally based on sex, that they would fire a lesbian employee just like they would fire a gay employee, that they would fire a transgender woman, a man, just like they'd fire a transgender woman, that there's not different treatment based on sex. And the 2 dissents have different tones. Justice Alito's is quite vigorously angry, where Justice Kavanaugh's is not. But they say, to my read, largely the same thing. So what does the majority, Justice Gorsuch says? Say that the employers are inescapably discriminating based on sex, even if they're really trying to discriminate because somebody is gay or transgender. So Justice Gorsuch says, for example, and I'm quoting from the opinion, if the employer fires a male employee for no reason other than the fact that he is attracted to men, the employer discriminates against that male employee for traits or actions that it tolerates in its female colleagues. Right? And then the court says, or take an employer that fires a transgender person who was identified as male at birth, but who now identifies as female. And Justice Gorsuch says, if the employer retains an otherwise identical female employee who is identified as female at birth, the employee is penalizing the transgender woman because for traits or actions that it would tolerate in a cisgender woman, meaning a non-transgender woman. And so the court says, whatever the other reasons, even if there's hostility to gay people or transgender people, the employer is firing an employee for traits, for not conforming, in essence, to traits or actions that it would tolerate in another employee. And the only difference is sex. Here's one more example from Justice Gorsuch. So for an employer who fires a woman, Hannah, because she is insufficiently feminine, and also fires a man, Bob, for being insufficiently masculine, may treat men and women as groups more or less equally. But in both cases, the employer fires an individual in part because of sex. Instead of avoiding Title VII exposure, this employer doubles it. And he goes on to make the same point in connection with gay and transgender employees. So why is this opinion such a big deal? Most people thought that federal law and state law already protected gay and transgender people against discrimination. In fact, There is no federal prohibition in employment against employment discrimination based on sexual orientation or gender identity, and less than half the states provide these protections. The court specifically says, well, we're not getting to questions about locker rooms or bathrooms or dress codes, but there continues to be substantial discrimination against transgender individuals in particular, and increasingly by the Trump administration against gay people as well, in a variety of areas. So having a determination that sex discrimination actually implicates sexual orientation and gender identity discrimination strengthens challenges to discrimination in healthcare, education, military service by transgender people, and much more. And in fact, we've seen some, in my view, good decisions come out in some of the schools at restroom access cases. So two very quick insider comments. One is there was a lot of worry before this decision came down that the court would gut Title VII's prohibition against sex stereotyping in employment. I filed a brief on behalf of women who are chief executive officers and other senior executives on that ground, and the court did not gut Price Waterhouse, as the case is known. That's a very important outcome here. Happy to talk about it more. The second, and really what is so powerful to me, is that this is the first judicial opinion about addressing the rights of transgender people. And not only does it rule for the transgender employee in this case, but the court also recognizes transgender people as human beings with full dignity and humanity. And we see that in the language choices that the majority opinion makes. And that is an incredibly important thing in any kind of case to be aware of. But if you read the arc of LGBT rights cases over time, you really see a change. And I encourage you to take a close look at the opinion and read with that in mind. Back to you, Dave.
Thanks so much, Professor Goldberg. So since we have limited time, I thought I'd limit myself to just one broad question for all the panelists who want to answer it. Picking up on a theme that some of you already started to sound, and which I'm sure a lot of people are talking about and thinking about, which is now that Justice Ginsburg has passed away, what do you think the law is going to look like in each of the areas covered by your cases in the immediate term or medium term, to the extent you can foresee? Let's assume that President Trump's nominee gets put on the court before the election, that there's no court packing or the like that changes the court's composition or ideological balance right back. So we just have Justice Ginsburg straight up replaced by one President Trump nominee. Notably, in all four of the cases you discussed, or five, since Tom had two, President Trump and the Trump administration don't get the outcome that they sought. But where are things going to go if Justice Ginsburg is replaced by someone with very different jurisprudence? Does anyone want to? I won't call on you. I'll just leave it to you to answer as you will. Where do you see the law going in light of Justice Ginsburg's possible imminent replacement?
I'll chime in. For immigrants and those with undocumented status, the law is only going downhill. I should say that DHS versus Regents is one of the only positive immigration cases coming out of the Supreme Court in the last few decades. So there is nowhere to go but down.
I mean, I think I already suggested this in my comments. Obviously, we have grave concerns about reproductive rights in general, including contraception cases and the Affordable Care Act case. But I try to never make predictions because we always are just fighting one day at a time.
And I think I'll just add that I think my overarching view is that civil rights cases and human rights cases are deeply interconnected, and that a downstream in one is like a sort of downward push in one area has implications for other areas, even if the doctrines look a little bit different. So that's tremendously concerning. I think in a case like Bostock, interestingly, and in some of the recent LGBT rights cases, we've actually had a 6-3 win. And so there's room to lose one justice, but you know, I think a lot turns on how Justice Roberts will approach cases, because it's pretty clear when we look at at the other justices who are known as the conservative wing, that none of them is, in general, other than Justice Gorsuch in this one case I was just talking about, has found his way to rule for LGBT rights.
Yeah, and similarly, the two subpoena cases were 7-2, so I don't think there's going to be an immediate shift in the outcome of those cases. And on the more broad trend of executive accountability to the law, I don't necessarily see that changing, but I suppose the question will become, does this get expressed in skepticism of the administrative state rather than certain forms of presidential action? And so I think that's kind of the big open question is you know, maybe peeling back on Chevron or certain forms of agency discretion, or independent agencies or things like that. So that I suppose there's a question of whether this holding the executive branch accountable will kind of get redirected in a potentially different direction.
Great, right, which we also saw somewhat this term, right, with the case in the Consumer Financial Protection Bureau. I want to not talk much further and open it up to questions from students. Maybe it's easiest if you do the raise hand function on Zoom so I can be sure to see you, or you can write by chat to Student Services. And but please come in now if you'd like. All right, I will ask another question if no one else is coming in. And okay, I'll do that while people collect their questions if you want to submit any or raise your hand. And the question that came to my mind, I was trying to think about themes that cut across these cases, although they're very disparate, obviously. And one that came to mind was something, a kind of unnerving theme about distrust of other governmental actors. Seems to connect some of the cases. So in DHS versus Regents, the court seems to fundamentally distrust DHS's grounds for rescinding Daca. And then in June Medical, as Nancy said, the court seems to find pretextual the Louisiana legislature's reasons behind its law. And Tom, you know, at least in Mazars, the court seems, I read the court to be skeptical of Congress's, the House's reasons for subpoenaing Trump. They don't say it's an invalid, they don't hold it to be a bad faith subpoena, but they seem open to the possibility that it's overbroad and was really out to get Trump politically rather than to inform legislation. I'm less sure about a distrust rationale for Bostock, but maybe we could strain to find one. But I wondered if any of you had any thoughts on this, that basically in these various postures, the court does not believe other governmental actors, and driving these opinions is a kind of pretext analysis, not necessarily said by that name to some significant extent. Is this fair?
Well, I would say yes, and in the world of restrictions on abortion accesses, for good reason they don't trust the state legislatures. I mean, we've just been dealing, some things are straight up, and frankly, I would always rather litigate a straight up case. You want to ban abortion at 6 weeks? Okay. You know, let's litigate that issue, or, you know, all these are unconstitutional, but on the grounds of you know, sex selection or anything, at least we're actually litigating about the legislation is actually what you're trying to do. But there's been a whole host of cases that have been about, you know, this pretext of women's health, or this pretext about whether certain procedures are safe or unsafe. And, you know, litigating those have always been like being in a, I don't know, Alice in Wonderland in a house of mirrors. And, you know, you can't even agree on what the facts are. Which is to say that many facts that are not accurate are put before state legislators and the basis for the rulings. So definitely in the field in which I work, the underhandedness of state legislatures is a pretty rampant thing.
I could just build on that for a second, that I think although this is, I mean, you can always tell a distrust story about Bostock, but I think when we look at the issue of faith-based exemptions in a wide array of gender and sexuality cases, some of what we see is a distrust of some government actors, or an expectation that they will be unwilling to protect the rights of people of faith as against people who seek to preserve their basic civil rights, to be free from sex discrimination or sexual orientation or gender identity discrimination. We've seen that in some earlier cases. We saw that in Masterpiece, the cake discrimination case, and I expect we'll see a lot more of that as well.
Yeah, and Dave, I think that's a good point with respect to the subpoena cases as well. I mean, I sort of take the beginning of the chief's opinion, the historical portion, to be a kind of tacit reprimand to the branches, which is to say, for over 2 centuries, you've been able to work this out among yourselves, going all the way back to the Washington administration when this has come up. And I kind of feel a little bit of frustration on the part of the court that it's being forced to referee that dispute. That said, I think the way that the factors are articulated, as you said, suggests to me a little bit more skepticism of Congress's motives than the president's motives here. In other words, those factors seem a little bit tilted in favor of the executive branch. But more generally, as I read the opinion, I think it is an attempt to provide a framework for these branches to be able to work things out among themselves without coming back to the courts, but in a way that puts a little bit of a thumb on the scale towards the executive. And that may just be because it's ultimately Congress that is the subpoena power, and they need to give some weapon to the executive in order to counteract that.
Elora?
Yeah, I was just going to say, in the interest of time, I'm going to pass it back to you.
Okay, all right. So there's one question that's come in. I'll read it. It came in on the chat, and I'll read it. And then everyone should answer if and as they wish. And then I gather actually we're at time, so we'll leave it at this question. Went quickly. The question is, if any of you have thoughts on Chief Justice Roberts as an authentic versus strategic actor this term, for the court's legitimacy or for the upcoming election. Chief Justice Roberts plays a major role in these, again, in Bostock, a little less so, but thoughts on the way he was operating this term, any of you?
Let me just say, excellent question, and I'm not going to answer it.
We have in Nancy and Tom 2 active, prominent litigators who have to be careful. So maybe our faculty members.
Happy to say something, although I'm not representing anybody in any case right now. Well, anyway, I think it is a great question. I guess the way I tend to think of each justice, on his or her own terms is, what can we see both in the votes that they cast and in the way that they write their opinions about how they are trying to, what version of judicial legitimacy they are trying to advance, right? One could say that an opinion that, like the Roberts opinion in June Medical, that, we respect precedent, that's, a traditional version of judicial legitimacy. Another justice might say that judicial legitimacy looks very different. It would be to correct prior overstepping of the judicial role by earlier courts and pull back and not, quote, legislate where courts are to achieve a particular outcome. So I think there's a lot of ways to think through the question, and the authenticity one is also very interesting. And I think one would have to know each person as an individual in a much deeper way to understand whether they are behaving strategically or authentically or both of those things in alignment. Elora?
So I just privately chatted with Professor Pozen to say that I'm on the board of an organization that soon expects to have litigation before the court, and I'm advising on several other cases that may go to the court, so I'm going to pass.
And I think you could take my response as a pass, but with some extra framing around it.
A filibuster. Okay, well, I want to respect the the time limits that were set on this panel. One downside of having such a high flying group who works before the court on prominent cases is some constraints on what can be discussed. But I still think we were able to get a lot of great material out here and cover a really important set of cases. So thank you so much to our panelists for being willing to share your perspectives and knowledge with us. And thanks to everyone for coming out for the event.